So, likelihood of confusion. Last week, I posted about likelihood of confusion and trademark infringement because that is the standard of trademark infringement. It also is important in registration. So, whenever we're doing clearance searching for, which you should be doing before you even adopt a trademark to make sure that you aren't likely to get a cease and desist saying that you are infringing someone else's trademark. That's one of the things that clearance searching does, is it applies this likelihood of confusion standard to whatever we find, both at the USPTO and also in just around in Google. So that's important. Again, with Google, we're looking at what's the chances of you getting a cease and desist because you might be infringing someone's mark if you were to start using this mark in commerce. The other part of it is the USPTO. So a common rejection, and it's something that the examiners at the USPTO are actively looking for. They are going to do a trademark search when they get your application and try to just make sure that there are no currently registered or active applications or registered trademarks that are likely to be confused with what you're claiming in your application. So likelihood of confusion, they will issue a rejection based on likelihood of confusion, or LOC as we call it, if they think that something is overlapping, that is likely to be confused with something that's already in their database and active. So they apply they're supposed to apply a 13-point test called the DuPont factors. The two most important and significant, the ones that usually that we start with, are how similar is the mark and how similar are the goods. And so I touched on that a little bit in the last video, that you can have two identical marks that are not confusing because the goods are sufficiently different that it would be unlikely that anyone would think, for instance, that this Apple Child Care is related to the maker of the iPhone. They're just so different that it's just not likely to be confused. Whereas in my example of Nike shoe repair, that would be likely to be confused, even though we don't know that Nike is doing shoe repair. If you were to see it, you might think that it was somehow connected to Nike because it's shoes and it's connected. So as you can see, there's no bright line where it goes from too close in the mark and too close in the services, and this is why it requires a human to make this determination. And we're always talking about likelihood. It's risks. So in the trademark office, there are other things that come into play. Again, adding words doesn't make it less likely to be confused automatically, but it might. It's just one of those factors where, depending on the words that you're adding, maybe it would. The other thing that's important, there's some other factors. I won't go into all of them here because we're already at 3 minutes. But there's 13 factors in this test that's applied by the U.S. Patent and Trademark Office. They use that version of the test. If you are filing a lawsuit for infringement, it's going to be a slightly different test depending on what circuit you're in. But they're all pretty similar. There are just some slight differences. So keep in mind that the test at the USPTO is not the same as the test for infringement outside of the federal circuit. So I hope that was helpful. Catherine Cabela, IP Works Law. Thanks.